scheduled court attendance on the hearing of the application that we had filed. We wanted the court to issue orders for recusal. There are 3 judges of the Anti-Corruption and Economic Crimes Division of the High Court that have expressed themselves in a manner that is prejudicial to the fair administration of justice, in a manner that is going to be not impartial. And we had hoped that there would be a hearing today, because we filed this application on the 18th of December under certificate of urgency. And we were given today as the hearing date, and we complied. We came to court, only for us to wait between 9 and 11 o'clock to be told that the judge has stated that she's not going to hear us, and that we should appear before the judge in the Economic Crimes and Anti-Corruption Division. I do not understand what it would have entailed to just inform us that the application cannot be heard and we have to await the High Court vacation to end, and then we come for hearing in the normal session. Because this is an application filed under certificate of urgency. And what we are saying in law is that Section 62, subsection 6 of the Economic Crimes and Anti-Corruption Act avails the governor as an elected office holder the exemption from the application of Section 62, subsection 1 of the Economic Crimes and Anti-Corruption Act. That means that you cannot tell a governor, stay away from office, collect your objects, and stay away during the pendency of the hearing of the case. That is the law. Section 62, subsection 6 forbids that and stops that. I am not saying that the court is afraid of now admitting that it has ruled in the wrong way. And I'm not saying that anyone is afraid of dealing with this case. But we're just saying that we want the adjudication of this case with expedition. But when you push the case to the 21st of January this year, not even for hearing, for directions, you are sending the message indirectly, implicitly, in an oblique way, that you are not prepared to hear these quickly. You do not want to give us a resolution fast enough. The administration of justice, in furtherance of Article 50 of the Constitution, requires that you hear a dispute impartially and expeditiously. But like they say, justice delayed is justice denied. There is an expectation that the judiciary is going to confront this monster that it has created by telling sitting governors to step aside when the law says they should not step aside. And we are not saying that any governor should be protected in the allegation of any crime committed of corruption or of such a nature. No. Parliament in its own wisdom passed Section 62, subsection 6. We cannot run away from it. We are accosted by it, and we must enforce it. Now, either we live by that, or we live like we are a Gestapo state, where we make the laws as we wish, where we close our eyes to the existing law, and we want them to say that we are a country that is ruled by the rule of law. If today anyone makes up an allegation, levels it against a judge, and says that this judge is corrupt, how will that judge feel if they are hounded out of office without due process, without giving them the benefit of the process of the law? Let us be very careful as Kenyans, while we fight this so-called fight against corruption, that we are not perpetrating injustice in the process of so doing. We must fight this fight. But we must use the tools not that undercut us, not that destroy the fabric of society or the faith in the administration of justice, but that foster the unity and the hope that we have in a judicial system
that is going to be impartial, that is going to be fair, and that is going to be just. But if we have a law that then is there for us to enforce, and we are closing our eyes to it, and we then want to say that we are a people that oppose the rule of law, we are deceiving ourselves. That's not fight. We are not fighting corruption. It seems to me then that there is another agenda that we would be perpetrating. And as a nation, we ought to question ourselves whether that is the path that we should go, and whether we are not sitting on a judicial, a legal precipice. I hope that we will get justice. And I hope that those who administer justice are prepared to administer justice without fear and favor and with impartiality, because that is how justice ought to be. What do we say about Section 62(6) of the Economic Crimes and Anti-Corruption Act? That is the elephant in the room. And I'm afraid someone somewhere is not prepared to address it. Okay?